Hello everyone, welcome to the 180 Q&A practice. We're going to start off today with the defense questioning. Okay, here we go. Ready? Dr. McDonald, or excuse me, Mr. McDonald, from the report, it shows the Ford pickup was 12 years old. Do you know if the Fargo Wells Company had recently purchased this pickup truck for company use, or if they had owned it for 12 years? They had owned it for 12 years. Did you know any of the problems with the vehicle? Did it need new parts? For example, headlights, brakes, tail lamps, windshield, or anything? It did not. As far as you know, everything was in working order? Yes, sir. The cause of the accident, in your opinion, wasn't in any way caused because of any mechanical defects in the pickup? Not to my knowledge, no. Did you see the plaintiff at all prior to the actual impact? Yes, I did. When you first saw the plaintiff's vehicle, where were you in relation to the stop sign that was on North Dakota Avenue? I saw his vehicle when I was leaving the number 2 lane. I was starting to enter the number 1 lane. Would this be the front of your vehicle? Yes. You were just starting to enter the number 1 lane? Yes. Okay, and where was the the plaintiff's vehicle when you saw him at that time? He was in the number 1 lane. Okay, and how far to the north of you was his front bumper from your left side? I don't know. Would the front of his bumper have been south of the north side of North Dakota Avenue if it had been extended all the way into the street? No. It could have been farther to the north than that? Correct. Would you say it would have been farther to the north by 1 or 2 vehicle lengths? 2 vehicle lengths. Did you arrive at a determination at that time when you first saw him as to how fast he was going? No, I didn't. Did you at any time arrive at a determination as to how fast he was going up to the point of where he struck your vehicle? No. So is it fair to say at this time you have no idea how fast he was going? True. Did you stop at the stop sign of North Dakota before you went across Van Buren Road? Yes. Did you come to a stop before the stop sign or at the stop sign, or did you slide past the stop sign and stop? I stopped at the stop sign. Did you stop at any subsequent time prior to your seeing the plaintiff's vehicle? Before you saw his vehicle, did you stop at any time from the time you stopped at the stop sign until you were crossing the street? No. Now, when you stopped at the stop sign, did you look to the left and to the right to see if the traffic was coming? Yes, I did. Did you see any traffic at all? Yes. And did you stop for that traffic? Yes. Now, which direction was that traffic coming from? I had been stopped there on account of traffic in both directions. This is a busy intersection. It is a busy intersection. At that time of day, yes. How long would you say you had been stopped there? A minute and a half. You kept waiting for traffic to clear? Yes. And then, did you think you had a clear passage through the street and you started off? Yes. And at the time you started off, did you look for both north and southbound traffic to see if you could go across? Or did it appear that at least half the street was clear, or, you could clear and be okay? No, I looked in both directions but you didn't see any vehicles at that time that you felt would prohibit you from coming across, is that right? True. And when you stopped then at the stop sign and started across, I presume from what you have said that you didn't see the plaintiff's vehicle at that time? No. As I understand your testimony, the first time you saw the plaintiff's vehicle was when it was at least 2 vehicle lengths north of North Dakota Avenue. Is that correct? Approximately. So you don't know where it came from prior to that? No. Okay, I'm going to switch transcripts. This is going to start off with the court. What are the duties of a pipe walker? Will you tell us that? Just inspect the lines to see if there are any leaks. Thank you. Do you also inspect the structures on which the lines are maintained? Yes. Why? To see if any oil or gasoline is showing on the surface. Is it also the duty of a pipe walker to inspect the structures on which the pipelines are maintained? You mean on the trestle? Trestles or any kind of structure on which a pipeline may be maintained. Yes. You are supposed to report anything unusual, is that right? Any kind of excavating that might be going on. Anything that may be dangerous to the trestle, is that right? That's right. When you first inspected this trestle, was it in the location in which it was on October 10? Yes. Has it been moved since that time? No. Do you remember how many pipelines there were going over that trestle at that time? 2. It had 2? That's right. Now, was it part of your duties to inspect certain warning signs that were located under the trestle? Once each week, I reported to the office that the signs were intact. What kind of signs were they? Warning signs. Where was the warning sign located? They hung on the trestle. Okay, I'm going to switch over to another transcript. Okay, what's the name of your case? Netter, N-E-T-T-E-R. Netter, okay, we can take it up. That was scheduled for a settlement conference today? Settlement conference. Okay, and you haven't been able to accomplish much, I take it? Unfortunately, no, Your Honor. William Anderson, on behalf of the petitioner who is present, they're in mediation right now on those issues. I'm pretty confident that we will resolve it, but I've been kind of confident all along that we wouldn't make it this far, and here we are. What issues? I guess the issue of the loan is a big issue. That's a big issue. That's about a $120,000 issue right there. We would hope that we would be able to resolve this, but it hasn't happened yet. We'd hope that the other side wouldn't make us or put us through what we are going through now. So, you know, we have to prove documentation what we feel that they know happened, but it doesn't appear that that is going to occur. We're going to need some more time. That's now set for trial. It's been set approximately 10 days away, I believe. Trial is set for August 26th. August 26th, what's your pleasure? I would first of all object to any kind of a continuance of trial at this time, mainly because my client has had to go to a great deal of expense to be here this entire day. We have fully prepared. We've got our statement of issues. We've got our statements of our income and our expense statements. We have our assets and debt statements. Did you deny that there was a loan in your response? Yes, we did deny that in our response. Again, we did not set any of this. We did not get any of this matter. What will a continuance avail to you? Well, I'm confident that we can come up with a copy of the check from Sophie Netter, that's my client's mother, to the parties. It's indicated from my client that the loan, you know, has been written out on that check. That would be one of a bit of documentary evidence, and also I believe that we can locate it. My client is confident about that. Okay, I'm going to switch over to one more transcript. Okay. I'd like to give you a variety of practice. Okay. Here we go. Back to plaintiff. There is no way you can crawl in his mind and tell us whether or not he is telling you the truth when he says that he didn't remember getting his gun or ammunition. Whether he does or does not remember it, I couldn't see it as being particularly pertinent. Well, don't you think it might be pertinent if he tells one psychiatrist that he remembered going up and getting the .306 and getting the ammunition, and tells the other psychiatrist he doesn't recall anything about the event? Don't you think it might be pertinent when somebody tells one person one thing and another person another thing about a very crucial situation, that his mind may be functioning and thinking about what is the best story to tell these people? I don't think whether he did or did not remember was a crucial thing. Let's say that he did not remember it. That still can't be used as proof positive that he didn't know what he was doing at the time, because the nature of retrograde amnesia is such that it's blocked off after the fact. If he did remember it, then I would have to say, find out when it was that he made the report. Again, it's not uncommon, if the report is made shortly after the incident occurred, for an alcoholic who has a history of alcoholic blackouts to subsequently not remember. So I really couldn't evaluate that as being of particular importance. If he told a psychiatrist the day before I interviewed him that he remembered it and told me on the day that I interviewed him that he did not remember it, that would be puzzling, since he reported to me the fact that when he talked with others, apparently after the incident, he said he did remember it. So it wasn't a matter of covering up the information, but just saying at the time that he talked with me, he didn't remember it. So you don't feel it would have a bearing on your opinion as to whether the defendant knew the nature and quality of his act, as to whether or not he knew he was picking up a rifle, and whether or not he knew he was getting ammunition for this rifle? Oh, I think it has some bearing on whether or not he knew, and I'm assuming that he did know the fact because he picked up a rifle as opposed to something else. Whether or not he remembers knowing it, I don't think is of particular significance. Okay, that concludes our 180 Q&A practice. Have a great day.